Here are some questions and answers about the EEOC's Enforcement Guidance on Pregnancy Discrimination and Related Issues. After the 2015 Supreme Court decision in Young v. UPS, the EEOC updated its guidance on this issue. Title VII of the Civil Rights Act of 1964 was amended by the Pregnancy Discrimination Act, or the PDA. The PDA clarifies that discrimination based on pregnancy, childbirth, or related medical conditions is a prohibited form of sex discrimination. It requires that employers treat women affected by pregnancy or related medical conditions the same as non-pregnant applicants or employees who are similar in their ability or inability to work. Does the PDA protect individuals who are not currently pregnant based on their ability or intention to become pregnant? Yes. The PDA's protection extends to differential treatment based on an employee's fertility or childbearing capacity. This means that having a policy restricting women from certain jobs may be illegal. For example, a rule banning fertile women from jobs with exposure to harmful chemicals are generally prohibited. The EEOC guidance tells us that an employer's concern about risks to a pregnant employee or her fetus will rarely, if ever, justify such restrictions. Sex-specific job restrictions can only be justified if the employer can show that a lack of childbearing capacity is a bona fide occupational qualification, or BFOQ, that is reasonably necessary to the normal operation of the business. An employer is also prohibited from discriminating against an employee because she has stated that she intends to become pregnant. Thus, demoting an employee with a good performance record 2 weeks after she informed her manager that she was trying to become pregnant would constitute evidence of pregnancy discrimination, according to the EEOC guidance. Is an employee or applicant protected from discrimination because of her past pregnancy? Yes, tells us the guidance. An employee or applicant may not be subjected to discrimination because of a past pregnancy, childbirth, or related medical condition. For example, an employer would violate the PDA by terminating an employee shortly after she returns from medically related pregnancy leave following the birth of her child if the employee's pregnancy is the reason for the termination. Close proximity between the employee's return to work and the employer's decision to terminate her, coupled with an explanation for the termination that is not believable, for instance, unsubstantiated performance problems by an employee who has always been a good performer, would constitute evidence of pregnancy discrimination. What are examples of medical conditions related to pregnancy or childbirth? Medical conditions related to pregnancy may include symptoms such as back pain, disorders such as preeclampsia, which is a pregnancy-induced high blood pressure, and gestational diabetes, complications requiring bed rest, and the after effects of a delivery, as well as lactation, are also pregnancy-related medical conditions. An employee who is lactating must be able to address lactation-related needs to the same extent as she and her coworkers are able to address other similarly limiting medical conditions. For example, if an employer allows employees to change their schedules or use sick leave for routine doctor appointments and to address non-incapacitating medical conditions, then it must allow female employees to change their schedules or use sick leave for lactation-related needs. Will an employer violate the PDA if it takes an adverse action against a pregnant worker based on concerns about her health and safety? Yes. Although an employer may, of course, require that a pregnant worker be able to perform the duties of her job, adverse employment actions, including those related to hiring, assignments, or promotion that are based on an employer's assumptions or stereotypes about pregnant workers' attendance or schedules or physical abilities to do the work or commitment to their jobs, are unlawful. Even when an employer believes it is acting in the employee's best interest, adverse actions based on assumptions or stereotypes are prohibited. For instance, it is unlawful for an employer to involuntarily reassign a pregnant employee to a lower-paying job involving fewer deadlines based on an assumption that the stress and fast-paced work required in her current job would increase risks associated with her pregnancy. An employer may only reassign a pregnant worker based on concerns about her health or the health of her fetus if it can establish that non-pregnancy or non-fertility is a BFOQ. The EEOC guidance warns Florida employers that in very few, if any, situations will a Florida employer be able to establish this defense. The EEOC guidance explains that some employer light duty policies may provide light duty only to employees who are injured on the job or who have disabilities within the meaning of the Americans with Disabilities Act, but a Florida employer may violate the PDA if it imposes significant burdens on pregnant employees that cannot be supported by a sufficiently strong justification. For example, one way a pregnant employee could demonstrate a significant burden is to show that her employer accommodates a large percentage of non-pregnant employees with limitations under its policy, while denying accommodations to a large percentage of pregnant employees. If the employer did not have a sufficiently strong justification for such a policy, an inference of discrimination would arise. Hope that helps you.